Everybody, welcome to the Monday, April 13th lecture in American Legislative Process. And I'm actually recording this on Sunday night. Um, and it feels like my house is about to blow over. The wind is blowing so hard. So if you can hear some background noise, I apologize. And if this video just ends very abruptly, then know that I did blow away and send somebody to come and find me. So quick little update. Again, recording this Sunday night, and my family and I have had a nice weekend. We're all still healthy and happy, which we're very thankful for. Had a nice Easter Sunday today. Taught my 4-year-old how to take photos using an iPhone today. So every time he was holding the phone, my wife and I were waiting with bated breath, hoping that he didn't drop it. And his little brother turned 2 on Saturday, so we hosted a Zoom-based birthday party for our family members who couldn't make it in person, unfortunately, because it was just the 4 of us. But nevertheless, he had a great time and ate a lot of cake and is now 2 years old. So anyway, I hope that all of you had an equally good weekend. I have very preliminarily started grading the annotated bibliographies. I anticipate having them done as soon as possible, hopefully by Friday. But again, you'll know sort of my setup at the moment, so I'm just going to get through as many of them as I can in a day, or each day, and hopefully by the end of the week they'll be finished. And I'm hoping to get feedback to you soon so that you can obviously start the final paper, which is due in about 3 weeks. All right, so today we're going to be talking about Congress and the courts. So we talked through the interactions between Congress and the president last week, and this week we're moving to the third branch of government, the courts, before we talk about the bureaucracy next week. And all of Congress's interaction with the court system in America comes under the shadow of judicial review. And judicial review refers to the ability of a court to examine and then subsequently decide whether a statute, a treaty, or regulation contradicts or violates either existing law, a state constitution, or the U.S. Constitution. And of course, the U.S. Supreme Court asserted its right to judicial review, which is found nowhere in the Constitution, in the Supreme Court case Marbury versus Madison in 1803. So all of the interaction between Congress and the courts takes place under this umbrella. Okay? And what I wanted to talk about this week is some research that my co-author, Jeb Barnes at the University of Southern California, has written about, and that sort of touches on my own research as well. And so this is just a case study, but it's a case study about interbranch policymaking. And so what is it about Congress that makes our courts in America have to behave differently? And if you have taken law, politics, and public policy with me, if you took it in the fall, then hopefully some of this stuff will be familiar to you. And the idea here is that it doesn't make sense, really from my perspective, to look at the institutions of American government in isolation from each other, because there is a system of separate institutions in the United States that share powers. And one of the powers that these institutions share is the policymaking power. So you simply can't understand what Congress does unless you understand what the president does and unless you understand what the courts do. And the courts in American politics for a really long time have not been thought of as policymakers, although I really try and make the case in law, politics, and public policy that that's not the case in American politics. And so we'll explore that a little bit further today. So the book Dust Up by Jeb Barnes is a case study at the end of the day that's about interbranch policymaking. It's about something called retrenchment. I'll get to what that means in a second. And also the judicialization of lawmaking. So if you think of who it is in American politics that makes the laws, normally we would say that that's a duty of Congress. And that, of course, the president then signs legislation into law. What Barnes argues in Dust Up and what he and I argue together in later work is that the lawmaking process in the United States has been co opted in some part by the court system, and that judicialization of policymaking is a very real part of the American policymaking process. And so, what this book represents is kind of a holistic way of looking at how Congress and the courts interact in the modern policymaking environment. And the takeaways of modern policymaking are the following: that it is really complex, right? And this should come as no shock to you as you're writing a paper right now about unorthodox lawmaking. Secondly, modern policymaking is simply unexplainable through specialized or isolated accounts of either legislative or judicial behavior. You've got to have both of them together. And that by putting them together, we see that policymaking comes from and emanates from different interactions among different branches and levels of government. And the reason why this slide is called a familiar context is because we are going to be talking about asbestos and black lung, which is something you've heard me talk about before. If you've heard me talk, or if you have media and politics right before this class, then you know that we already discussed our article about framing. So apologies again if this is going to be redundant, but nevertheless, I think that our research kind of fits into multiple categories. And I'd rather, talk about something that I know well than something that I may not know as well. So that's why I keep coming back to this well. But nevertheless, we know that the modern policymaking process tends to be afflicted by the following characteristics. So we know that political majorities in Congress tend to be very narrow, right? So the Democrats for almost 2 years enjoyed a filibuster-proof majority in the U.S. Senate from 2008 until Ted Kennedy died of brain cancer in 2010, right? But beyond that, neither party has enjoyed a filibuster-proof majority in the Senate in a really long time. And so what that means is there's constantly a veto player kind of trolling the waters in the Senate. Secondly, both parties in Congress are highly ideologically polarized. So we have narrow parties just separated by, 2, 3, 4, 5 votes in terms of majority versus minority, but those parties are very far apart on the ideological spectrum, right? And so the distance then between the median voter in the Republican and Democratic parties has actually more than doubled since 1980. And what this means is that the majority party, even when it controls the presidency and Congress at the same time, simply cannot unilaterally advance its policy agenda at the federal level due to the ever-present threat of the veto. And we see this borne out time and time again, even when the Republicans controlled the presidency and Congress from 2016 to 2018. As we've talked about in here, they tried and failed 3 times to repeal and replace Obamacare with something else. So the policy problem that we're going to talk about as a case study is the occupational hazard that the mineral asbestos posed American workers in the 20th century. And tens of millions of workers throughout the U.S. in a multitude of industries were exposed to asbestos during the 20th century. And they worked in industries from creating brake pads for cars to installing fireproofing in ships that were used by the Navy in World War II, to working insulation in buildings. And if you're unfamiliar with asbestos, it's a mineral. So it's mined. There are, for example, huge asbestos mines in Montana and Canada. And as a mineral, asbestos possesses some really pretty amazing qualities. It's stronger tensilely, so its tensile strength is stronger than steel. It's waterproof, it's fireproof, and it also, in sort of repeated exposure, causes cancer and disease in human beings who deal with it. So asbestosis deaths, one of the conditions that you can get from asbestos is asbestosis. If asbestosis turns into cancer, it turns into a disease called mesothelioma, which I'm sure you've seen commercials for the attorneys who handle mesothelioma litigation. They'll often advertise on TV in the middle of the day. But nevertheless, asbestosis deaths in the United States increased 20-fold from the late 1960s to the early 2000s. And a lot of the early fights about asbestos exposure centered on who was at fault, which we'll get into in a minute. But regardless of who was at fault, workers dying because of exposure to toxins during the course of work must demand a policy response, right? So this is something that, for example, the United States Congress was made to address, right? One worker, not a problem, maybe an anomaly, but tens of millions of workers exposed to something that in sort of with the right amount of quantity will almost certainly kill them has to demand a policy response from a national legislative lawmaking body. And people on both the American left and right were arguing that the asbestos problem was not a political issue, it was a public health issue. And for all of us who right now are living during this pandemic, this language should be familiar to us. Yet, nevertheless, Congress did not respond. We'll talk about reasons why on Wednesday, but Congress sat on the sidelines and to date actually has not passed a comprehensive compensation policy for sufferers of asbestosis or mesothelioma. So let's talk about the problem a little more. The United States in the post-World War II era rapidly industrialized. And so you had many, many, many millions of workers exposed to asbestos again in all sorts of industries. And one of the earliest pieces of litigation was from this case called the Burrell case in 1968. And the Burrell case, using a novel or a new application of what litigators call strict liability. What the Burrell case did was it essentially allowed for third-party asbestos manufacturers to be sued as part of the kind of supply chain. So, for example, if somebody worked in a shipyard, then the company that mined the asbestos that they then sold to the shipmaking company, basically every company along the chain could be sued. And early litigation, like the Burrell case, brought out some really, really troubling corporate wrongdoing. Basically, documents, including this example of the Sumner-Simpson papers, that asbestos manufacturers had known not only for years, but for decades about the health risks that were associated with prolonged handling of asbestos as a mineral. And as a result of this early litigation, litigation rates in the United States regarding asbestos skyrocketed through the 1970s, 1980s, and 1990s. And asbestos litigation, meaning people trying to get compensated for their injuries through the court system, became a form of policy response to a health-related crisis, because remember, Congress was sitting on the sidelines. The action was taking place in the courts. Where was Congress, right? Where were they? We'll talk about that in a second. But the American response to the asbestos crisis has been remarkably contentious and litigious compared to other countries that have had similar amounts of industrial exposure to asbestos, like the Netherlands, for example. So has asbestos litigation then been an efficient and effective means of responding to the underlying policy problem, right? So when somebody gets sick, what asbestos litigation entails is that they hire an attorney and they find companies to sue. So is that an efficient and effective means of responding to this problem? And almost universally, by any metric, the answer to that question is no. So in the 1960s and 1970s, asbestos litigation performed pretty admirably. As I mentioned, it redressed wrongs when simply there was no other recourse for sufferers of asbestosis or mesothelioma to get compensated. It uncovered corporate wrongdoing. It allowed sufferers to overcome very weak state workers' comp programs. It allowed for the increased awareness of asbestos dangers, and of course, as I just mentioned, it uncovered corporate wrongdoing. Yet over time, asbestos litigation began to exhibit all of the tenets and hallmarks of a term that public law scholars in the United States call adversarial legalism. And my apologies to those of you who are in law, politics, and public policy. This is maybe going to cause some PTSD flashbacks for you, but adversarial legalism is a specific way of describing the American court system. And its hallmarks are slowness, inefficiency, and uneven and perhaps unfair rates of compensation. So before we move forward, let's figure out exactly what adversarial legalism is. So if we're thinking of people trying to resolve disputes, we can think of the dispute resolution process along two different lines or axes. So the first would be how formal or informal the dispute resolution mechanism is. The second would be how hierarchical or participatory it is. So when we're talking about formal or informal, we're talking about the rules and procedures that govern the process. So it can be very uniform, it can be very reliant on precedent, and here that would be an example of formal rulemaking, or it can be ad hoc and very nebulous, and that would be informal, and I'll give you examples of these in a second. As for hierarchical and participatory, this refers to the level of participation by either the people who have been injured or their advocates, so lawyers, in the dispute resolution process. So a hierarchical process is almost entirely dominated by a judicial official, like a judge, whereas a participatory process is dominated by the disputants and their advocates, lawyers, right? So participatory, lawyers, hierarchical, judges. And this is how this works in practice, right? So here on the x-axis, we see all the way to the left a completely informal system. Formal is on the right, so a high reliance on precedent. The other axis up at the top is hierarchical, judges dominate. Down at the bottom, it's participatory, lawyers dominate. And so you can think of specific systems as looking like this. And we're particularly interested in these two over here because, as you might guess, the UK, France, and Germany are kind of similar cases to the US. The Soviet Union over there in the upper left, interesting case study in and of itself, but is not a very similar or analogous country to the United States. And so in the UK and in France and Germany, practicing this system of bureaucratic legalism, they tend to rely on formal courts, right, which is what we do too. But as you'll notice, they're on the hierarchical side of things, and we're on the participatory side of things in the system of adversarial legalism. And this is a really, really, really important difference because in bureaucratic legalism, it's not the attorneys that provide the energy to the system, it's instead judges. And in the US, we're the exact opposite. It is, with some exceptions, obviously, but it's mostly entrepreneurial lawyers who are making the system run and who are being proactive about bringing cases and litigating and so on and so forth. So adversarial legalism, we can say then, refers to the propensity in the US, especially when you compare it to other advanced industrialized countries, to rely on a, quote, legal style of politics. And this emphasizes lawyer-dominated litigation in policy making, in policy implementation, and in dispute resolution, right? And so if you have lawyer-dominated litigation in policy making, again, where does this leave the United States Congress, right? When we have this huge chunk of the policy-making pie taken up by the courts in the US, that is a very American-centric thing to do. The US simply handles more political problems in the courts than any other industrialized democracy. And the list of political problems that we have handled in the courts is long and is growing every year. So from deciding the 2000 presidential election to legalizing gay marriage to playground safety to desegregating school districts in the South. I mean, the list of Title IX problems. The list of things that are handled, policy problems that are handled in the courts in America is just stupendously long. So adversarial legalism, this process of handling dispute resolution in the courts in a very formal and participatory way, has some benefits. So it allows the legal system to actually sort of fix policy wrongs, right? So there can be some heroic action by attorneys to hold unresponsive industries accountable, right? You can think of the Brown versus Board story, where, of course, the Supreme Court desegregated schools in the South. Congress did not act there, right? That was only because we have this adversarial legalism system that the courts were able to step in and make such a huge policy shift. It also allows for flexibility, creativity, and access to the policymaking process. So even though I know it may be intimidating to think of hiring a lawyer is a relatively cheap proposition compared to trying to lobby Congress. And so if you pay a lawyer to file a lawsuit, you're sort of automatically on the court's agenda, and the policymaking process can begin in earnest. But despite these benefits, there are some real drawbacks as well. So the courts in America are slow, they are costly, they are inefficient, they are uneven, and in the case of unelected federal judges, they are arguably undemocratic. And so the puzzle then that we'll be talking about next time on Wednesday is, if asbestos litigation is so woefully inefficient and unfair and has been failing for years, decades now, why has Congress repeatedly failed to replace it? And the answer to this question, I think, really gets at the relationship between the courts and Congress and helps us to better understand why Congress has not acted, why the courts have filled the void, and what that can tell us about the modern policymaking process and the modern role of Congress and the courts in that process. And so, again, if you were in my course last semester, some of this may be review, but hopefully we're starting to think about it in a bit of a different light. And hopefully that process will continue on Wednesday, which is when I will talk to you again. So I hope that all of you have a great start to the week, that you had a great weekend and a happy Easter if you celebrate Easter, and are doing well and are staying safe and healthy. And I will talk to you Wednesday. Bye.